I am only going to assist your lordship on 2 points which I need to assist. Was there a settlement? There's suggestion is that this was something more than a settlement or less than an adjudication. And if so, on what basis is the settlement being challenged?
Salve, it was a settlement. I don't think any of us doubt it was a settlement. Yes, court prods. At times, court prods, there's no doubt about it. Day in, day out in trying to arrive at settlements. We may have played the local scenario, the court may have played a little more active role in trying to do so. In family matters, every day we do it. Sometimes the bench comes, they say, leave it to this. Okay, we say X amount is a settlement. You want to agree to it, you don't want to agree to it. And then they say, okay, we leave it to the court too. You know.
There was a reason why your lordships did that, because the district judge had passed a judicial law asking the parties to settle or explore a settlement. So the process had been started by a judicial law. And that carried its, there were 2 parallel themes which were running. While the settlement was going on, the district judge said, I can't wait and see people queue up like this. Something needs to be done. So he passed an interim saying peso, which both sides challenged in the High Court. High Court upheld the principle but scaled
it down, and then that came up to
came up in appeal. So there were 2 parallel tracks running. Try and settle, and in the meanwhile pay. Those 2 were sort of coalesced here, where your lordship said settle, if you can. The appeal was argued for weeks and weeks in Court 1 before Justice Pathak, while there were also conversations happening about whether this can be settled, because this had to be or not settled obviously at very high levels, at the top of the management of the private company and at the top of the government. It had very far-reaching implications. And that is what was done. So there was a settlement. Now, what has happened pursuant to that settlement? Your lordship sees this one document so that the nature of the curative becomes clear. Page 329, P7. In the course of submission, various questions came up. Actually, what exactly was paid? Are there any claims outstanding? A lot of these matters are answered.
Yes.
The death figures are 5295. These are paid. Death transferred to injury 10,000, permanent disability 3,000, temporary disability 33,000, injury of severity 40,000, minor injuries 521, loss of livestock 233, loss of property 547, PSU 8, total number of cases 5,74,000, compensation paid 154,856.
These are the figures given in the review application.
Curative application.
Curative. So this is how Malak they paid 1548. Came back to your lordships saying we still have 1,500 lying in the kitty. So pro rata compensation given. Now, what the curative petition tells your lordship is page 150 of volume 1, if the lordship sees it side by side. Curative CP1, CP volume 1. The lordship keeps this page open and compares the figures.
What page are you referring to?
150.
150.
And if your lordship looks at D, column D, and compares it to the number of cases column at page 329, death 5295, permanent disability is actually 4902 as against 10,040, sorry, permanent disability is 4902 as against 3199. Temporary disability is 35 as against 33. Utmost severity is the same, 42. Minor injuries, 521 to 527. It's not much of an increase. Loss of property, loss of livestock. It's not that what has been paid and what are the actual number of cases in the curative are dramatically different. What then are they claiming? They are saying compare the figures in D to the assumptions of 4th May 89. What we have assumed and what have actually transpired are different. Now, what had they assumed? They had assumed 3,000 deaths. It turned out to be 5,295. They had assumed 30,000 permanent disability. It actually turned out to be 4,900. They had assumed 20,000 disability temporary. It turned out to be 35. Utmost severity was 2,000. It actually turned out to be 42. It's this 50,000 assumed. It became 5,27,000. Loss of property 50,000 turned out to be 555. Loss of livestock 50,000 assumed to be 230.
That even from the chart the attorney had given to us, where the figures were given, we had put to him the real issue is of the solace amount paid to the persons with minor injuries.
Not even that also has been paid.
No, paid it has, but this is where the figures rose.
The figures rose from what was assumed in 1989.
Yeah.
Now, the question of law, which you have to consider in a curative, is if the Union of India, which was perfectly aware of the uncertainty of the situation, thought that that public interest would benefit by a quietus of signing the settlement at 470 billion in a full and final settlement, can come back and say, if you knew that the permanent disabilities would be 500,000 instead of 50,000, you would never have signed this settlement. And assuming that is so, does that become a ground to set aside a settlement? Point number one. Point number two, can you add top up? Because unionists are not saying set aside settlement. They did. At one time they did. Today they are not saying set aside. And this is the fundamental difference between the review and the curative. Let me not put to one side the question about the procedure which your lordships have put. The attorney has answered, nothing I can usefully add. On whether, without filing a review, a curative can be filed. It is not merely a matter of procedure. There was something more troublesome there. If the union had to file a review, it would have had to elect on whether it wants to continue with the settlement or whether it wants to discontinue the settlement, scrap the settlement, and say, we don't care about the settlement. Start the suit.
So why would in a review they be required to say so?
Well, it's binary. Either you stay with the settlement.
No, that's the same thing today.
No, exactly. So they don't file a review.
Even in a review, they would have said, look, we don't want to disturb the settlement, top it up, as they are saying in the curative.
They didn't.
They did. As a fact, they did.
No, what happened is something very interesting. Because your lordship will know the background. The review petitions I'm not saying it may be that it's a technicality that the union representing the review petitioners did not itself file a review, but it came and supported a review, etc. So you may say, in that sense, broadly, the Hura test is satisfied. I'm going on that piece. Taking up time on it. But then that creates.
Salve, having heard the attorney for such a long period of time, we are not going to shut him out because the curative has not been
Exactly.
taken. So
I am not wanting to point out something else. Your lordship tells.
Mr. Salve, one more thing, please. This was a settlement in this court. Now review is filed. Review is granted. Now under Order 43, the grant of review is appealable, specifically as an order of court. Now, if you're going to shut him out on curative aspect, then it will lead to a very.
I'm not saying that. I'm not saying that. That's why I said
that's what
I'm not addressing a lot.
we already indicated. We have flagged that issue, but on that,
But that's why I said I
would
don't even
not
want
like to shut out the.
I only said I'm not going there. What I want to show my lord is something.
To that extent, you are right.
What I do want to show my lord is what exactly happened. To inform the court. Please turn to volume 6, additional documents filed by us. This is the review petition prayers.
You mentioned the review petition prayers were to set aside the settlement.
Yes, I want to say.
But that's the by the other people.
The union said we support the review.
But the union never argued that the settlement be set aside at any stage.
I remember right in the opening, a subject matter dear to my Lord Justice Khanna and my heart came up, tax law. Because one of the first questions which came up was, having appropriated the money under a settlement, can you challenge the settlement? Then Attorney General, my guru, Mr. Sorabji said, we have not appropriated the money. We produced a copy of the finance bill. Because there was a question of taxability of the interest on the purpose. So a provision was introduced in the finance bill appropriating this money and saying it goes to the exchequer. So there'll be no interest. There'll be no tax on the interest. So we said this constitutes appropriation. So this issue was very much at large. And what the union asked for is not set out fortunately for us. As Justice Venkatachala said, because nobody was hurt, we didn't keep it in the traditional confines of a review. Like your lordships have heard, this case much beyond the confines of security. Their lordships, in fact, said we will hear if the settlement has to be set aside. That is what was being heard. Because at page 1433, just to get the record straight. The Lordship read that rather poignant comment by Justice Rangnath Mishra. But it's very easy to say, go try the soup to those who have no stake. Those who know the realities, the uncertainties of litigation will never make that clear. Look at page 1433. Review the orders of settlement. Allow the appeal of the Union of India against the Madhya Pradesh High Court and confirm the order of the District Judge Bhopal. The Lordships have been on this. Direct the disposal of 350 crores as the interim compensation to the victims. So, my lord, this would be on the basis that the judgment goes. So, we are back with the appeal. Allow the appeal of the Union of India against Madhya Pradesh because the High Court had appealed down the pro tem compensation from 400 to 250 crores. So, allow the appeal of the Union, confirm the order, direct 350 crores as interim compensation out of the sum deposited by UCC, retain the balance of the amount paid by UCC in the court as security to satisfy the final decree in the suit.
What was the total amount paid in court at that time?
But this was the total amount paid under the settlement, i.e. the 400 odd million. 470 million.
Probably before the district court it was 270, and the high court it was 140, and when it has come to this court, then it was 470.
Yes. So, but that is how, and that money was paid pursuant to settlement. So the review petitioner
I was only saying what was the amount which is already in court, either in district or high court.
No,
Because-
by the time this was filed,
Yes.
the entire amount under the settlement had been paid.
So that was under, so you brought in more money under the settlement.
Yes.
So that's what I'm saying. I'm saying originally what was lying in the court was
5 billion.
deposited.
I don't think, I mean, subject to
So
correction.
pursuant to the interim direction,
There was a direction to pay.
I'm saying pursuant to the direction of the district court and high court, was any amount deposited or
No,
not
because that was carried in appeal.
deposited? So it was not deposited.
No.
That's a fact I want.
And the appeal came here.
That's fine.
Post settlement, the entire amount was brought in. And there's a certification, it's all noted.
So it's 5 million paid pursuant to the US Justice Kennan's order. 5 million. That was the only advance amount paid.
Okay.
Rest was all paid later on.
Very small amount.
That's para 2A.
There's a very interesting thing I've discovered in this. Although people retire, even in the US, they have the right to call back judges. Judge Keenan kept hearing the Bhopal case in its repeated avatars. Even post-settlement, Marat 3 trials ahead. They used to call him back. I think the last order he passed was at age 90 or something. He heard an action because they used to call him back to hear the Bhopal case.
The lighter side, your suggestion is all reviews here should be dealt with in the same manner.
But we have to seriously consider, even in the English courts, retired judges are so many times called back by the commercial court, come for a few days, sit, decide individual cases. Page 1433, Malay.
Yeah.
If your lordship sees the operative prayers. So what they said is of the settlement money which has come in, 350 you distribute, which is as per the interim order. Retain the balance as security to satisfy the final decree. Please mark the words. In the suit against it pending in the district court of Bhopal, and direct the speedy and expeditious disposal of the suit against the UCC by the district court and pass other consequential orders. The union cannot file a counter affidavit, which is at volume 7, and that makes important reading.
In my SPP underline, like in my volume and yes.
This is volume 7. Correct?
What do you want to show us from this
Yes.
volume, Mr. Salve?
Please turn to page 1594. In the middle of the paragraph,
Yes.
the victim groups submitted.
Yeah.
The victims group submitted certain material and studies to the government. Thereafter, the government took a fresh look at the matter, with particular reference to the long-term effects and potential hazards of the exposure of MIC and other toxic gas. And it was realized that an important element involved in the determination of liability in the assessment of compensation damages was overlooked, as stated here and after. While directing settlement, the court took into account the number of fatal cases at about 3,000, and the number of cases of grievous and serious personal injuries as verifiable from the records of the hospitals of cases treated at Bhopal was taken to be in the neighborhood of 30,000. Obviously, one of these figures didn't come from Union Government, it would only have come from the government. It is submitted for reasons stated that the figures are not accurate and do not furnish a sound basis for assessment of compensation damages to the people who have been exposed to MIC and toxic gases. It is further submitted that medical studies on the effect of MIC and toxic gases formed in the leakage have been conducted under the auspices of the ICMR, and further studies are being conducted, and a whole chart of other studies is given. Your Lordship turns to page 1596. The results already obtained clearly show evidence of psychiatric disorders such as anxiety, neurosis, and depression, pulmonary damage, visual disorders. With regard to pulmonary damage, etc., etc. Then, my lord, page 1597. My lord, some suggestion being made at that time, cancer was not known, this was not known. 1597, fourth line. Besides, there is a likelihood of carcinogenic effects which may be manifested over the years. Research and investigation in this regard are continuing. In addition to the studies of long-range effects are in progress in order to evaluate genetic risk, organic brain damage, damage to the immune system. Follow-up studies are being conducted in children, etc., etc. Page 1598, para 8. It is also necessary to point out that while the court proceeded on the basis that the number of dead was 3,000, the total number has gone up to 3677. The figure is based on records showing ex gratia payments to the next of kin. It is therefore submitted there is every possible of the number of dead increasing as the various results of the gas leak manifest themselves over a period of time. Then, the environment damage, etc., is all mentioned. And the operative, then of course they challenged successfully the quashing of the criminal case. And page 1608, para 23. The union says the settlement requires to be reviewed.